I'm John Strohmeyer with Strohmeyer Law. Today we're going to be talking about the statutory durable power of attorney form here in Texas. What is it? Well, this is a form that we use in estate planning to allow one person, known as the principal, to give the power to another person, known as the agent, to do things on behalf of the principal. Essentially, you're saying, I authorize this person to do these things for me. Now, the common law on this is that you can always authorize any person to do something for you. What this form does, so the statutory durable power of attorney, the key word is durable. It means that that power of attorney remains effective even if the principal is later incapacitated. So what we're looking to do is make sure that if something happens to the principal, somebody can act on their behalf to take care of business, move assets, manage things for them. A regular power of attorney isn't going to be durable, and that means that upon the principal's incapacity, the agent is going to lose the right to transact business on behalf of the principal. So you can probably see why we'd want to set this up. For a husband and wife, we're going to want to set up a document where each spouse will be a principal and they'd be likely naming the other spouse as their agent. So if something happens to one spouse, the other spouse would still be able to take care of business for the family. Now, this may be something that could address a situation such as one spouse gets in a wreck and is in a coma, but it could also deal with a situation such as, well, if one spouse is out of the country on a trip or just unable to make it to, say, a house closing, well, the other spouse, the agent spouse, can take that power of attorney form and go and sign documents on behalf of the principal spouse while they're unable to sign that document. Other things we may want to use this form for, well, you may want to authorize somebody who does business in your name to take care of business for you. So setting up a power of attorney for somebody to manage real estate for you, but not giving them full power to deal with your bank accounts or other assets. One way of thinking of this and how I typically explain it to clients is this is a broad form that will give you a lot of power, give your agent a lot of power if you give it to them. If you want to think about it this way, a principal can authorize their agent to sell their house, sell their car, empty all the bank accounts, invest it in risky options in the stock market, and then run off to Mexico and live off that money. Now, it doesn't mean they're supposed to do that, but this is the amount of power you're giving to a person. Things to think about, well, who should you name? You obviously don't want to give this power to somebody you wouldn't trust with your checkbook. You also want to think about, well, when will this be effective? Should this person be allowed to, should your agent be allowed to operate immediately? The moment you sign that document, can they take a copy of it and walk into the bank and start transacting business? Or do you want to wait until you're incapacitated so that that person can only do work for you then? Now, a thing to think about is if you don't trust the person with that power right now, if you don't trust them to be your agent while you have capacity, are you going to trust them more once you don't have capacity? Something to think about. So to wrap it up, statutory durable power of attorney is a form that we use to help people take care of assets while they are either with capacity, meaning they can do things themselves, or if they're incapacitated. This allows work to be done for that principal by their agent.